Thank you. Our first witness will be Ms. Kathleen Sullivan. Ms. Sullivan is a partner in the New York office of Quinn, Emanuel, Urquhart, and Sullivan, LLP. Previously served as Dean of the Stanford Law School, and she taught constitutional law at both Stanford and Harvard. She has argued 11 times before the Supreme Court and is the author of a scholarly article about women's equality. She received her JD from Harvard, her BA from Cornell, and a BA from Oxford, where she was a Marshall Scholar, served as a law clerk for the Honorable James Oakes of the Court of Appeals of the Second Circuit. And Ms. Sullivan, Dean Sullivan, you're recognized for 5 minutes.
Thank you, Chairman Nadler, Chairman Cohen, Johnson. Thank you for the honor of allowing me to testify today in support of the Equal Rights Amendment. Thank you. Chairman Nadler, Chairman Cohen, Ranking Member Johnson, thank you so much for the honor of allowing me to testify today in support of the Equal Rights Amendment, which would add to our Constitution the guarantee that equality of rights under the law shall not be denied or abridged by the United States or any state on account of sex. It would also provide that Congress has the power to enforce the amendment by appropriate legislation. As noted by Congresswoman Maloney and Congresswoman Spear in their eloquent remarks, the United States Constitution, the world's oldest written constitution, is also the only major written constitution in the world that lacks a provision declaring that men and women are equal. And now is the chance to correct that omission, that stain, that embarrassment about our Constitution through the ratification by just one more state of the 1972 amendment. Just to give some examples, the French Constitution provides that the law guarantees to the woman in all spheres rights equal to those of men. The German Constitution provides that men and women have equal rights and that nobody shall be prejudiced or favored because of their sex. The Constitution of India provides that the state shall not discriminate against any citizen on grounds of sex, and every written constitution promulgated since World War II contains a sex equality provision, but not ours. Given the vital role the U.S. Constitution has played in inspiring and informing the written constitutions of other nations, this is a situation that cries out for correction. Now, you might ask, why do we need an Equal Rights Amendment when the United States Supreme Court has interpreted the Equal Protection Clause, passed in the aftermath of the Civil War and erasing the stain of slavery from our existence and declaring equal protection above all for purposes of preventing race discrimination? Why is it not enough that sex discrimination has been shoehorned into the Equal Protection Clause through judicial interpretation? And make no mistake, the decisions that were brought about in the United States Supreme Court through the brilliant advocacy of Ruth Bader Ginsburg as a young woman working together with other women and men to bring about those interpretations, make no mistake that those decisions were momentous and important. But they are no substitute for having an Equal Rights Amendment in the Constitution. The decisions of the Supreme Court do not have the strength, the endurance, or the efficacy of an express constitutional amendment. They are the product of transient and shifting judicial majorities. We, the people, speak through our Constitution with more permanence than any court majority through its decisions. As we made clear when 4 times in our history, we passed amendments overruling decisions of the Supreme Court. This nation should proclaim fidelity to the foundational principle of sex equality that will endure for the ages to come and not turn on the vicissitudes of Supreme Court appointments. Finally, I'd like to make the point that this Congress absolutely has the power to clear away any impediment that the deadline imposed back in the 1970s might be thought to impose to ratification by just one more state. And here's why. And I want to adhere to 3 very conservative principles of constitutional interpretation in making this argument: textualism, originalism, and federalism. First, the text of Article 5 provides that the Congress whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, which shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states. Article 5, the text, places no time limits on the state's ratification process. Nothing in Article 5 says that ratification must be synchronous, contemporaneous, or bounded within any particular time frame. To the contrary, Article 5 says valid when ratified, and that is the end of the matter. Second, our history confirms as much. The 27th Amendment, which prevents congressional pay raises until an intervening election of the House, was proposed by James Madison and the first Congress back in 1789, and yet it became our law when the 38th state ratified it in 1982. No one questions that the 27th Amendment is an amendment to our Constitution, and what's good enough for James Madison is good enough for the women of America. Finally, in addition to the text and history, our constitutional structure supports the idea that Congress can remove any impediment to the state's ratification when the 38th state decides to join. The framers split the atom of sovereignty in two. The states have independent powers. Article 5 gives the states the powers to ratify, and consistent with the structural principle of federalism, Congress should view itself as lacking the constitutional authority to fetter the ratification process of the states, and certainly as having the authority to lift its own self-imposed deadlines. For those reasons, I respectfully urge that HJ Resolution 38, proposed by Congresswoman Spire, is proper, constitutional, and merits swift markup and adoption by the House. Thank you very much.
Thank you so much.